I started with the fact. I'll hurriedly go through. That the entire crux is to the effect that the persons who did not require any surgery in any manner whatsoever were brought to the hospital and eventually made to undergo firstly angiography and thereafter angioplasty, which eventually led to the demise of two persons. That is how an FIR came to be registered by virtue of a report by a committee on 13/11/2024. The present applicant appears to be accused number 3. Having been named in the FIR, initially he approached your lordships with a CRMA 3597 of 2020. It came to be rejected by this honorable court on 3/12/24. The applicant did not challenge this order before the appellate forum, and on the very next day, that is on 4/12, he surrendered before the investigating agency, remanded till 12/12, and since then he's been in judicial custody. Thereafter, the charge sheet came to be laid on 7/25. He cited as accused number 7. In all, 125 witnesses are cited by the prosecution in this charge sheet. So, hurriedly, I'll tell your lordships who is the applicant and what is his role in the organization, because that would make some difference. The applicant happens to be an obesity surgeon having an illustrious career of more than 25 years. He started a city hospital at Rajkot in the year 2006, and thereafter in the year 2012, he started Asian Bariatrics Hospital at Ahmedabad along with 2 other bariatric surgeons. In the year 2021, those 2 partners ventured out and 3 new partners came in, which are accused in the present case. And that hospital came to be renamed and converted into Khyati Multinational, a multi-specialty hospital. The applicant happens to be one of the 3 non-executive directors in the company, along with the fact that he is in charge of the bariatrics department, which is a separate unit altogether, because in all there are 22 departments within this hospital, of which bariatrics is one of them. Apart from his services and directorship with Khyati, he happens to give his services in 3 other hospitals and runs in Ahmedabad and 4 obesity centers across India. So this is how the applicant is placed before your lordship. Now, from the perusal of the entire charge sheet, it runs into almost 1800 pages. Barring the statement that the applicant is one of the directors, the entire charge sheet is silent for any act, overt act, or omission by the present applicant. So, in my respectful submission, as I could gather from the charge sheet, the applicant is arranged as an accused in the present case by way of the principle of vicarious liability, for the reason being that he happens to be director of this organization. Now, in my respectful submission, as far as criminal law is concerned, the concept of vicarious liability is foreign to it, save as except provided if the statute provides so, as like in 138 or drugs and cosmetics, etc. But as far as IPC or rather now BNS is concerned, except for 149, which provides for the concept of vicarious liability of one individual to another, none of the other sections which are invoked in the present case provide for the concept of vicarious liability. So therefore, even when in special acts as in negotiable instrument, etc., when the case is defined for non-executive directors, the Honorable Supreme Court time and again has said that specific averment has to be made as to the role of that particular accused, which again in this case is not there. So, correctly again, some allegations against the present applicant, I'll take your lordship to that. First is at the cost of reputation. Non-executive director, not involved in day-to-day affairs of the company. The said fact comes from the statement of one Thoralben. Second, they say that the license of the hospital is in the name of the applicant. The license is obtained under Section 5 of the Bombay Nursing Home Act. The requirement of the license is that, okay, you are allowed to start a hospital by virtue of this license, and that license is used to obtain various other licenses and permissions from the electricity department, AMC, water department, waste management services, etc. So this is the requirement of that license, and the applicant being one of the only persons with a medical degree, the license is in the name of the present applicant. There is no gross illegality of having a license in the name of the doctor of the organization. That is my respectful submission. Again, at the cost of reputation, the applicant is concerned only and only with the bariatrics department. As many as more than 10 departments of this hospital are registered with PMJ, except for bariatrics. Bariatrics is the only department which is not registered with PMJ. So the applicant has no direct connection with this scheme floated by the government. Secondly, the charge sheet, and I could gather from your lordship's order, one of the reasons is that Dr. Vajirani, who performed this surgery, was not registered in PMJ. Now, if your lordship permit me, I'll not take your lordship to the statement per se, but the statement of Dr. Nishit Shah. Actually, can I tender that statement? Yes, or I may read. You can read. I'll read that. Because most of the portion are I'm conscious, but I'll also have to. Yes, yes. Because not only the presence of the person, but the. Yes, yes. So therefore, I am. Yes. Sir, statement of one Dr. Nishit Shah, who was the project manager, rather the general manager of this entire PMJ scheme. He categorically says that Dr. Vajirani is registered in the portal with SGS Hospital, and apart from this hospital, he is permitted to provide his services in 3 other hospitals. And there in the drop-down menu, there is an option of others. So by virtue of that, that surgery is performed. Again, the present applicant not concerned with that, but since it is forming part of one of the allegations in the charge sheet, I am addressing on that aspect. Cursorily. Now again, as far as the entire incident pertaining to that cardiology procedure is concerned, starting from holding of camps, the checkup at the camps, at the hospital, pre-checkup at the hospital, the procedure, and post-op. The applicant is nowhere connected to that aspect. Now, the entire theory of the prosecution starts on the premise that in order to gain some ill-gotten money from the scheme, this entire device has been mechanized by the organization. The scheme starts from the camp. At the camp, there are 2 doctors, namely Dr. Ajay and Dr. Meenal, whose statements are also recorded. They say they had performed the initial checkup of the persons at the camp. I take a logic. And thereafter, they were recommended to come at the hospital the next day. At the next day, again, they are examined by these 2 individuals who are again a witness. They stick by their reports. They stick by the reports, the preliminary report given by them that these people required further examination, and therefore they are recommended to this. If this scheme, the prosecution would not be permitted, rather your lordship would not permit them to pick something from here, pick something from there, and then put up a picture before your lordship. When the first preliminary reports, the prosecution is sticking to that, then they cannot say that subsequent procedure, though in furtherance of the common conspiracy, is made out. That is my respectful submission. Third is, much emphasis is laid on the fact that 16.64 crores is obtained by the company in the past. Now, as far as the present applicant is concerned, it comes from the statement of one Viral Bhai. 3 things I will draw your lordship's attention to. First, the applicant has not taken any salary as a director. Second, the applicant and his wife happen to be shareholders to the tune of almost 39%. No dividend is obtained. Third, though the charge sheet has not supported the figure which the IO has provided in the affidavit. However, I have made a statement in my petition also that those amount is for the services provided by the applicant and his wife, who happens to be a gynecologist in that hospital. It is not supported by the material of the charge sheet, but since the affidavit of the IO says, I am drawing your lordship's attention to that fact. Third, when you are going back and taking the honorable court to imagine a scenario that 16.64 crore is an ill-gotten money, that would be the only thing which the prosecution would want to derive the honorable court. In my respectful submission, I'll take a lordship to that. There is an audit in procedure. PMJ, the entire procedure. Yes. If you want to permit me, what some exercise I want to take. If the logics may have that first flow chart of the transaction management system. Is the honorable court having? Sir, I'll just hurriedly go through this. Sir, there is a procedure prescribed before performing the angiography. The patient is registered at the hospital. It is checked whether he is having that card, Ayushman card or not. If he is having that, then initially a medical history of that patient is taken. Thereafter, the basic medical checkup of that patient is undertaken, which includes BP, ECG, RPS, and ECO. All these data, along with the patient photograph and doctor's prescription, is uploaded in the portal. Now, I'll take a look to that. The portal says it comes with from the statement of one of the witnesses that at the portal, it is managed by the doctors connected with this very scheme of the government. Whenever I upload that data in the portal, it goes to a random doctor. It is not the case that a specific doctor is sitting at the portal or the other end, whom I must have connived with, who has given this approval. In the facts of the present case, as far as these 18 individuals are concerned, the approval is given by 12 doctors. So, is the prosecution trying to say that I had connived with these 12 doctors whom I did not know beforehand that to these people it is going to get assigned to? So, after that approval by that doctor, the angiography is performed. Again, the second step in this audit, in this procedure, I have to upload the angiography report and the picture of that blockage. Again, it goes to some random doctor who has not given the permission of the angiography in the first place. He gives his approval and thereafter this angiography is performed. Very well. To claim that benefit, I have to upload the documents of that entire procedure, the sticker of the stent, that it is not merely a procedure on paper. Thereafter, it goes to the claim panel doctor, another third person. He gives an approval and then only this amount is credited in the account of the hospital. So it is too fast-paced to imagine at this stage that the hospital must have connived with all the doctors sitting in the panel to whom randomly this file goes and they have given this approval. Because they are not an accused in this case. The approval given by them is not into question at this stage. So therefore, in my respectful submission, when they say that in the past 16.64 crores is derived, a question mark cannot be put at that at this stage. That is my respectful submission in view of the safeguards provided by this very scheme itself.
Yes.
Secondly, they say that false audit reports are given before the honorable court. In my respectful submission and with utmost humility at my command, I do not know what it derives at. Merely by stating a fact that false audit reports are given doesn't take the case of prosecution any forward. That is what my respectful submission is. Merely because the person whose digital signature of one of the directors is used by the auditor, audited by a third party. It is audited by a third party, I'll tell you logic the name, Kothari and Gupta Associates, who has performed the audit of this company. That audit cannot be called into question after all these years, that too, without putting that in the papers of the charge sheet. Now, again, after this amount is disbursed by the organization, the scheme of the government, there is an audit provided. If the logic permit me.
Yes, yes.
The safeguards provided in this audit are, firstly, in the present case, 4 surprise visits have been made by the department and 3 planned visits. In that audit, if the logic permit me, there are safeguards of data audit. Second, live patient audit, that is the patients who are admitted therein. Third, patient home visit. Fourth, telephone feedback from the patients, whether any money is charged by them or from the hospital from them or not. Fifth, desk audit of all the documents of this scheme availed by the hospital. And lastly, even the death audit of all the patients is undertaken by third party appointed under this act. So even those people are conniving with us, that is too far-fetched in my respectful submission. Lastly, the entire prosecution, and rather the ball got rolling in view of the report submitted by the committee on 12/11. That committee included one cardiologist by the name of Mr. Dubey. If I am not wrong, Mr. Thakkar has extensively argued on that aspect that it did not have a stent in the PM report, whereas his report says that a stent is there. Now, if your lordship may kindly have that another chart that I have given of 19 patients, if the honorable court.
Yes, I have gone.
Sir, for my satisfaction, if the honorable court may kindly. So initially 89 persons came to the camp, of which 19 were recommended to come to the hospital. Now there are two groups in that. These 19 angiography was performed. 10 persons, for 10 persons, angioplasty was suggested. And for 9, it was very well not suggested because they do not require. Of these 10, 3 consented. I'm sorry, 3 did not consent, 7 consented. Of these 7 consented, 1 person did not have the PM data. This chart is self-explanatory, I understand. Now, what I'm trying to draw your lordship's attention to the fact that the smoke screen that is being created, that the persons who did not have any illness whatsoever have been made to undergo this procedure, in my respectful submission, is materially flawed. For the reason that even as per this committee, all these persons were having blockage. The difference is the variation in the percentage of blockage. In my respectful submission, I have annexed documents to that also. It is a subjective term. It is not the straight jacket formula to determine the blockage of a person, but the fact remains that each of the person was having this blockage, and considering the fact that the initial report is materially flawed in the sense that person who did, where there was no stenting, a stenting has been done. So I am before your lordship at this stage seeking bail. I understand that if I was under 482 or 227, the parameters would be different. Lordships are well versed, the parameters of 439 are well defined, and I did not take your lordship to that. But the fact remains that I have been charged with 105 akin to 304 of the earlier act. Now, in my respectful submission, 304 is, lordships are aware, is not a penal provision. I'm sorry, it is not a defining provision, it is merely a penal provision. It provides for punishment of culpable homicide not amounting to murder, divided in 2 parts as per the scheme of the act. One pertains to intention, which carries a higher sentence. Second is pertaining to knowledge, which carries a lesser sentence. However, the fact remains that this is an offense of fixed sentence. The parameters of fixed sentence, I take everything against me. Even lordships are aware, under 389, after conviction, the parameters for fixed sentence are set out by Bhagwan Rama Shinde Gosai. So at this stage, even pre-trial, I am before this honorable court that I am facing prosecution for a fixed sentence. Lordships may kindly consider my application for regular bail when the investigation has been concluded. Prior thereto, anticipatory bail stage, I understand lordships are of the opinion that requires custodial interrogation. Very well. But now the investigation has been concluded. Therefore, I am before this honorable court. As far as 304 is concerned, again, mens rea is important, which in the facts of the present case is not there. Second is the principle of causa causas. The direct act which led to the demise of the individual is not fastened on the present applicant. It is again at the principle of vicarious liability that I am sought to be probed in. Another 2 sections, forgery and cheating. Again, vicarious liability, no direct involvement. I did not induce anything. I did not forge any document. That is not even the case of prosecution. However, the fact remains that as per the scheme of the new code, both the offences carry a sentence up to 7 years. So, in my respectful submission, again, Arnesh Kumar would come into play less than 7 years. That is my respectful submission before the court. Now, again, as held in P. Chidambaram, the tripod test, not of light risk, no possibility of tampering with the evidence, and availability of trial. In the facts of the present case, none of the contingencies prosecution could bring, which would not entail the present petitioner for the relief. And hurriedly, some a short, very short comparison. I'll not take your lordships entirely through that, but I'll just tell what they are about. Prosecutors have the index. The first is the case of Sanjay Dutt in 2025. The principles of vicarious liability. Even in that case, the statute did not provide for vicarious liability. The Honorable Apex Code, in paragraph 11, 12, 13, and 14, defines what is required to rope a person in by the concept of vicarious liability. Next, Sunita Kavita, no doubt under 138. However, the principles of vicarious liability in case of non-executive director have been defined by the Honorable Apex Court, and the findings thereof Lordships will find on paragraph 42 and 43. Next, an application for item number 3.
How would the judgment help you?
Which one?
Sunita.
Sir, Sunita, for the reason that when a statute provides for vicarious liability under the NI Act, then to the Honorable Apex Court says that as far as non-executive directors is concerned, they are not involved in day-to-day affairs of the company, and without giving any specific allegation against that individual, you cannot rope in a non-executive director even in 138, let alone IPC and BNS offenses. This is what I want to derive. The third one pertains to Hooch tragedy which took place in 2022. Again, case of directors, including the managing director of that company, the Honorable Apex Court, our Honorable High Court says, paragraph 13.13 onwards, granted anticipatory bail, discussing all the concept of 304 as well as the concept of vicarious liability. More particularly when there is no direct connection of the accused with the crime in question. The fourth one pertains to the Kakaria ride accident, wherein again, which in 2019, if you also recollect, a discovery ride had collapsed, wherein all the employees and chairman of that organization were accused of 304. Again, after filing of the charge sheet, the Honorable Court exercises discretion in favor of the chairman. Fifth is very important. This pertains to Herni incident. In the Herni incident, after charge sheet regular bail, I have annexed the order of the manager. However, everybody is out on bail. But here, if your lordships permit me, I'll read 2 paragraphs. If I'm not wrong, this has not been brought before your lordship. So I permit me to read this. Yes. Lordships may come to internal page 5 of that judgment. Am I with the honorable?
Yes.
Paragraph 7. There is no dispute as regards the fact that the activity of the boating was being run on behalf of the Baroda Municipal Corporation. It is the argument on behalf of the prosecution that the principle of vicarious liability would make all the accused persons equally liable for the offence. If this argument is to be accepted, then first one to be vicarious liable would be Baroda Municipal Corporation and its office bearers from time to time. The VMC, despite having recommended several safety measures in the tender documents as well as subsequent agreements, do not appear to have bothered to inquire as to whether those safety measures were being rigorously complied or not. The investigation carried out by the investigating agency is absolutely silent on the aspect of complicity and complacency of the officers of the VMC. The entire charge sheet is conspicuously silent as regards to the cold shoulder approach of the VMC. The FIR in question has been lodged by an employee of the VMC, which conveniently does not speak about the complacency of the VMC and its officers. This court is unable to digest that for all these times, the VMC was not aware about the fact that the agency was awarded had entered into a subcontract, so and so further on facts. And lastly, paragraph 8.
Yes.
The role attributed to the present applicant in the office is to the effect that he was working as manager at the Lake Zone and was employed with Dolphin Entertainment. Neither any specific role has been attributed to the present applicant in the charge sheet filed by the investigating agency, nor the present applicant was present at the time of the incident. Again, as like present case, the applicant has been arrested in commission, so and so, the other accused have been so and so. The aspect as to whether an offence punishable under 304 is made out or not would require a detailed appreciation of evidence. The prosecution has cited as many. Why I laid emphasis on this decision is because, as I said earlier, in the past, the audits have been performed by the officers of this very scheme, including surprise audits. The approvals have been given by the officers of this scheme, which the prosecution stands by those. So by standing by those approvals and those audits, now subsequently coming with the story that everything which was done in the past is wrong, in my respectful submission, is not the correct approach, and lordships may kindly deprecate that aspect. Last 6th item, which is again, lordships are well aware of this. I will not take your lordships to that. The findings are at page 50, paragraph 53 onwards, 53 to 57. Even till this date, even in that case, when there was a statutory mandatory bar against grant of bail, and the twin conditions have to be followed, the Honorable Apex Court says that even in that aspect, bail is a rule, jail is an exception. And lastly, very well known, Sanjay Chandra, I will not take your lordship to that. But one thing I forgot, they say that I have attended meetings with the other directors, and that is an offense. Because in that meeting, you have conspired to derive illegal benefits from this scheme. Now, in my respectful submission, meeting between directors of an organization do take place. There is no gross illegality in that. But taking the honorable court to go on the principle of conjectures and surmises and saying that you have conspired in those meetings without there being any evidence whatsoever. Because one thing I'll take your lordship to, this is very important. The agenda has been provided in the copy of the charge. The minutes of meeting of this 8 meeting which have interested taken place are also on record. Nowhere it is stated what the prosecution is trying to elicit before the honorable. So in my respectful submission, when the picture before the honorable court as put up by the prosecution is as hazy as it can be. And in the past, when the officers of this very scheme have approved everything which was done in the past, that would entail the present applicant at least for bail at this stage. And lordships are aware, 2 another FIRs. I have not been arrested. So consciously, I can assume when my anticipatory bail is rejected, they are not arresting, so they don't need my custody. That is what I am assuming at this stage, subject to them saying otherwise. So in my respectful submission, lordships can kindly consider my application.
જે ડાયરેક્ટર છે સર એકમાત્ર ડોક્ટર મેડિકલ લેંગ્વેજ જાણનાર ડાયરેક્ટર તરીકે એકમાત્ર સંજય કોટડિયા હતા આખી હોસ્પિટલ. એમનો સાહેબ 39% એમનો હિસ્સો હતો. એમને દરેક મિટિંગમાં હાજર રહી અને એવી સૂચનાઓ આપતા હતા કે ભાઈ પેશન્ટ આપણી હોસ્પિટલમાં વધારે લાવો અને એમના એન્જિયોગ્રાફી અને એન્જિયોપ્લાસ્ટી વધારે. અહીંયા સાહેબ એટલા માટે કરતા હતા કે એક એન્જિયોગ્રાફી એક દર્દીની કરવામાં આવે તો એમને પીએમજેવાય યોજના હેઠળ 4,428 રૂપિયા મળતા. એન્જિયોપ્લાસ્ટી એક દર્દીની કરવામાં એમને એક સ્ટેન્ટ નાખવામાં આવે તો એમને 91,714 રૂપિયા મળતા. એક જ દર્દીને 2 સ્ટેન્ટ નાખવામાં આવે તો એમને સાહેબ 1,27,548 મળતા. અને એક જ દર્દીને જો 3 સ્ટેન્ટ નાખવામાં આવે તો 1,63,000 જેટલી રકમ મળે. એટલે સાહેબ જે જીગર રમેશભાઈ કલ્સરનું નિવેદન છે એ નિવેદનમાં સાહેબ 91% આ હોસ્પિટલમાં 91% પીએમજેવાય યોજના હેઠળ સારવાર થતી હતી, 9% 10% કેશથી સારવાર થતી. અહીંયા આગળ જે નેહાબેનનું સ્ટેટમેન્ટ છે, નેહાબેનના સ્ટેટમેન્ટમાં ડાયરેક્ટરો માર્કેટિંગ ટીમ વાળા આ બધું અમને સૂચના આપતા હતા વધુમાં વધુ દર્દી લાવો અને અહીંયા દાખલ કરો અને એન્જિયોપ્લાસ્ટી કરો. એવી જ રીતે સાહેબ ડોક્ટર જીત બ્રહ્મનું સ્ટેટમેન્ટ છે કે અમારી હોસ્પિટલના કાર્તિક પટેલ ચેરમેન અને ડાયરેક્ટરો ને ટાર્ગેટ આપતા હતા કે ભાઈ તમે પેશન્ટને દાખલ. એટલે સાહેબ આ આખા ષડયંત્રની અંદર એ મેડિકલ પ્રોસિજર જાણકાર છે. એ જાણે છે કે કોઈ પણ વ્યક્તિના શરીર સાથે ખોટી પ્રોસિજર કરવાથી શું થઈ શકે. એટલે એમનો હિસ્સો અને જોતા સાહેબ એમને અત્યાર સુધીમાં 2 કરોડ પ્રોફિટ ડાયરેક્ટર તરીકે રૂપિયો લેવાનો નથી. એમને તપાસમાં પણ એમને સાહેબ પ્રોફેશનલ ફીના નામેથી એમને 2,59,00,000 રૂપિયા સાહેબ આ હોસ્પિટલમાંથી 3 વર્ષમાં મેળવ્યા. અને એમની વાઇફના નામે એમને આ હોસ્પિટલમાં પોતે એક નવી કંપની બનાવીને સાહેબ એમને હોસ્પિટલમાં જે સાધનોની જરૂરિયાત હોય એ સાધનો પ્રોવાઈડ કરેલા છે. એના પણ સાહેબ એમને 3,52,00,000 જેટલી રકમ સાહેબ મેળવી ટોટલ. એટલે સાહેબ હોસ્પિટલમાંથી એમને ગેઇન મેળવ્યો છે અને રોંગ પ્રોસિજર કરીને સાહેબ આ એકમાત્ર ડોક્ટર હોવાને કારણે એમને જાણતા હતા. એટલે સાહેબ આખું ષડયંત્રની અંદર સાહેબ પહેલેથી તમામ હકીકતો જાણે છે અને અટકાવી શકતા હતા. એટલે સાહેબ આ એમનો રોલ જોતા કૃષ્ય રોલ હોય સાહેબ જામીન અરજી રદ કરવાનું છે.
For my satisfaction. My learned senior friend says that I was giving instructions. Again, a figment of imagination, I'll use this term, a figment of imagination of the investigating agency. Where is the material to that effect? Second, my friend, learned senior friend refers to the statement of Nehaben and Jeetbhai. In the entire statement, except for the fact they consciously say that X person or Y person has asked them to do this or that. It doesn't refer to the name of the present applicant except in the first opening para that I was one of the directors. That is my.
પ્રશાંત રજીરાણીની રિક્વેસ્ટ એમને પોર્ટલ પર રજીસ્ટર કરાવવા માટે મોકલી હતી ખ્યાતિ હોસ્પિટલ તરફથી પણ સર એ 3/5/24 ના રોજ નામંજૂર કરી દીધી છતાંય સર 3/5/24 પછી પણ એમના હાથે સર ઓપરેશનો કરવામાં આવેલા અને જે દિવસે ઇન્સિડન્ટ બન્યો એ દિવસે ડોક્ટર પ્રશાંત રજીરાણીએ 1919 એન્જિયોગ્રાફી કરી હતી અને 7 એન્જિયોપ્લાસ્ટી કરી જ્યારે એમની રિક્વેસ્ટ નામંજૂર કરેલી છે એ પણ સર રેકોર્ડમાં છે પેજ નંબર 1435 ઉપર છે. યસ સર.
Was not present in the camp. Statements are there. It was also not the case that I advised somebody from the camp that you go for a medical treatment. That the doctors did, my lords. Page 73 of competition also that comes up. Statement not have annexed. That, and I am not qualified, my lord, for giving any medical opinion that you go and you conduct you require a surgery or you require some medical assistance. That was not done by anyone. The patients, my lord, when they came to the hospital on 11th November 2024, they were advised to go to the general ward, whereby my lord, general tests were done, the readings were taken, and then they were advised that to go to the cath lab where angiography is to be done. All the operations were taken care of in the cath lab. My presence in the cath lab, my lords, is also doubted. The reason, my lord, I say this because the cath lab in charge twice being examined, once by the Vastrapur police, once by the PCB, never mentions that I was there. Lord, I believe he is the only eyewitness, only neutral eyewitness, my lord, who was present there in the cath lab even throughout. He was assigned the duty of being the in charge and managing the whole cath lab. He never states that I was present anywhere in the cath lab. In fact, my lords, the initial statements taken by the patients who were treated, they also nowhere state that I was present. And my lords may see the patients are recorded, the statements of the patients are recorded after the entire thing broke out. I was a known figure till then, my lords, till the statements are taken. Nowhere nobody names that I was there. Subsequently, my lords, other agency comes and takes statements wherein major improvements are done. My humble submission, my lord, would be that major improvements, those incriminate me, which were not initially there, my lords. This, my lords, I am not asking my lords to appreciate the evidence at this stage. I am well aware that my lords will not appreciate the evidence at this stage, but my lords, glaring improvisation. That, my lords, I am requesting that my lords must see to it that there is a glaring improvement. Such an improvement which directly incriminates me. Earlier, nobody is saying. In cath lab's in charge statement also, my lords, he is not mentioning that I was there. In multiple, he was given chances, my lords. Once, I am not inclined. What is? I am not inclined. Lordships. I'm just, for my satisfaction, I'm just putting forth my submissions. Further, my lords, they say that I was pressurizing the doctor or I am influencing the doctor. Nowhere, my lords, in the entire chat sheet, it is the case that I have advised, I have directed or requested to the doctor to do certain things. Lords, may please have page 112 of my petition, that is statement of an ex-cardiologist who was working with the hospital. Nowhere it comes that he says that no, I was being pressured by the management to conduct certain operations, or I was being requested or advised or nothing of that sort. Dr. Kalpesh Hamsora's statement, he was an ex-cardiologist working with us, visiting cardiologist, just like the present court. Nowhere he says anything that I was pressurizing or advising or requesting even. That you conduct such and so, you perform a medical function in such manner, nothing of that sort comes up, my lords. Further, my lords, they are saying that the whole scheme, the state government was defrauded by putting forth unnecessary operations and gathering funds from them. For that, my lords, I would invite my lord's attention to page 119 of my petition, wherein the general manager of the PMJY scheme is examined. It is recording. The statement is recorded. When Nishit Shah, Dr. Nishit Shah, my lords, page 119. Third para, my lords, third para, last 3 lines. The third para. ख्याति multi-speciality hospital. Come with my lords. Third para, last line. ખ્યાતિ મલ્ટી સ્પેશિયાલિટી હોસ્પિટલમાં 2022 થી આજ દિન સુધીમાં 3 વખત પ્લાન વિઝિટ તથા 4 વખત સરપ્રાઇઝ ઓડિટ કરવામાં આવે છે.
Everything goes.
But also, it is not even the case that something dubious was found out. Never happens. My respectful submission would be that if at all there is any irregularity, it would have come up earlier, or even once, my lords. That is not the case. That is not the case. In fact, my lords, the time of the FIR also, my lords, the present incident is to be seen.
Have you seen anyone suffering from fever 102, 104 for 5 days in your family? Have you seen anyone?
Lords, my humble submission.
Sorry,